Hi everyone, welcome from Law with Dunk, the Law Guy. It's been a while, but hoping to be more consistent, and so we're back with day 66 of the case series journey, covering cases across criminal law, tort law, contract law, and the English legal system. Today, I'd like to cover the case of Wood, brackets Fraser, v. Director of Public Prosecutions, 2008, and its relevance to the criminal offence of battery. You'll remember that in Collins v. Wilcock, 1984, the Day 63 recording, a police officer committed a battery upon a woman whilst grabbing her, i.e. the direct application of unlawful force, as she walked away. After the police officer attempted to question the lady after suspecting her of being a prostitute. The police officer had no rights under law to detain the lady. The lady was therefore acting in self-defence when responding by scratching the police officer. In the case of Wood, brackets Fraser v. DPP, so Director of Public Prosecutions, 2008, a similar issue arose where, in order to check Wood's identity, a police officer took hold of his arm. Specifically, a report had been made to the police that a man called Fraser had thrown an ashtray in a pub at another woman. The ashtray didn't happen to hit anyone, but still smashed on impact. The police eventually arrived to the scene, and 3 police officers approached a man leaving the pub who they thought was the man Fraser, but was in fact a different man named Wood, the appellant in this case. Wood had one of his arms taken a hold of by a police officer, and Wood was asked if he was the man Fraser, to which Wood denied and began to struggle, hoping to pull away from the police officer. Another police officer then seized Wood's other arm. Wood was subsequently charged with assaulting police officers in the execution of their duty. The first police officer who first grabbed Wood by the arm argued that he did this in order to detain Wood, but that Wood was not under arrest at this point. The court decided that as Wood was not under arrest at this point, the police officers had technically committed a battery upon Wood, i.e. there had been the unlawful physical contact committed upon Wood by the officers, and this amounted to battery because Wood had not been arrested or informed he was under arrest when they grabbed him. As a result, Wood was entitled to resist and struggle, i.e. he had a right to resist, and was not found guilty of the offence of assault upon the police officers. And that's it for the case, but before I go, I just want to say that if you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. Also, just in reference to the other platforms, be aware that the case recordings are available on TikTok, YouTube, Instagram, Facebook, Twitter, and are beginning to become available on Spotify too. Simply search Law with Dunk, the Law Guy, or at Dunk, the Law Guy. And to law teachers and students who may prefer an electronic copy instead to read from or use for various resources in the classroom, you can go to the Law Guy _Law Library Shop on test.com, where there'll be both PDF and Word document equivalent resources available. These resources are also available on Kindle. Once launched, I'll be uploading these to my website too, which will be called thelawguide.co.uk. And that's it for today. Thank you from Law with Dunk, the Law Guy.